Should I make them the beneficiary of my other trust, of my land trust? Should they be the trustee? And the answer is you usually don't have a trust be either a beneficiary or a trustee of a trust. Personal property trusts, there's only a half dozen or 8 or 10 states that have actual laws that talk about personal property trusts. In any other state, basically your personal property trust is going to be known as a living revocable trust. But Florida has specific personal property trust laws, and so you can have a trust that holds your personal property, but it's usually not going to be the beneficiary or the trustee of another trust. You're going to have an individual or a corporation or an LLC be the trustee, and then you're going to have individuals be the beneficiaries. I get the asset protection question all the time. Well, if I have my trust, my land trust or my revocable trust, and then I have an LLC be the beneficiary, that gives me asset protection. And I've got to admit, I have thought about it. I've hurt my little brain thinking about it. And I've talked to a lot of really bright lawyers, and we just cannot see what asset protection you get with a beneficiary LLC, LLC being the beneficiary of the trust. And you usually don't, like I say, make a personal property trust the beneficiary of a trust either. And gurus say, well, if you make the LLC the beneficiary, then you get asset protection. No, you don't. The asset protection is, well, if the trust is revocable, then the answer is there is no asset protection. The grantor, the settlor, the trustor, whoever that guy is, the guy who sets up the trust, if he gets in trouble, we just make him revoke the trust and give us the assets back. So generally in in a revocable trust, you get zero asset protection out of the revocable trust. So I wouldn't worry about it. Revocable trusts, the question is, what changes will Biden make to the revocable trust laws? And the answer is, I don't know. I would be shocked if there were actually changes to the living revocable trust laws, because it's really not, I'm going to say, political. The last time that we actually had a change in the laws associated with living revocable trusts was like 1978. And even at that, all the states except California, welcome to California, all the states said, if your trust reads this way, then the new law says that this is what it means. And so you didn't have to even change your trust. In my career, my 40-year career as a lawyer, I haven't seen a change in the living revocable trust laws. Now, how the estate tax works changes quite often. And I do expect Biden will lower the estate tax limitations. Right now, it's at 11.68, 11.7 million. You can die and pass 11.7. Your spouse can die and pass 11.7 if we do it right. So you get what, $24,000 or $24 million out to the family without having to pay an estate tax. That's a big deal. Now, I do expect that Biden will lower that. He said maybe $3 million. Most of us are still not going to have to worry about the $3 million, particularly if the husband can get $3 million and the wife can get $3 million. Now, those of you who have property, I understand you're still clipping coupons and you're watching the money and everything else, but technically you could be well worth $3 million because we're going to take the total equity in the pieces of real estate. So, you know, you could get there with 3 million. They've also said that they're going to do away with the estate tax. If they do away with the estate tax, everybody goes, woohoo, we don't have any estate tax anymore. That's a disaster, guys, because when dad dies, all of the property gets a step up in basis. Technically, it's taxed at his death. You receive a credit, a tax credit, we call it the unified credit, and it will pay the estate tax. So technically, it is taxed.
Tying into existing platforms.
Richard, is that you? Better mute out. Thanks. Basically, everything is taxed, but it gets a step up in basis. So if they do away with the estate tax, then when dad dies, his property won't get a step up in basis. And what you're going to have to do at that point is pay income tax. So dad bought the house for $50,000. Today it's worth $500,000. So when dad dies, it's taxed at $500,000. It gets a step up in basis. If there's no estate tax, then it won't get that step up in basis. And when you sell the house for $500,000 after dad dies, you're going to have $450,000 in income. So it's going to be a real bad affair if they do away with the estate tax. And they brag that, well, Canada doesn't have an estate tax. Well, yeah, they have a deemed disposition tax. When dad dies, you're deemed to have disposed of all of his assets, and you pay income tax on the difference between his basis and what you sell it at. So it's a disaster, in my opinion, if Biden does away with the estate tax. If he lowers it to $3 million, then he'll give us enough credit to pay the tax on the $3 million. That's the way it works. But we'll get a step up in basis. And if I get 3 million, my spouse gets 3 million, that's 6 million. Most of us aren't going to worry about estate tax. So it's you know, that's the way we play the game. The question is, do we have added benefits in a C corporation structure? Specifically, the question says, can I pay my kids out of the C structure? And the answer is no. Well, you can pay your kids, you give them a W-2. But in a Schedule C business, that's a sole proprietorship, then you can pay your kids and you don't have to collect the Social Security, FICA, and all that stuff on them. So it works out to be an advantage if you are a sole proprietor and you are paying your kids. But you don't get that in a C corporation. There really aren't many advantages in benefits to a C corporation that you can't get in an S corporation or even a partnership or a sole proprietorship. There are benefit plans that are unique to a C corporation structure. Now, this could be an LLC taxed under Subchapter C or Subchapter C. Under Chapter C, it could be an LLC or it could be a corporation taxed under Chapter C. So it doesn't matter the legal structure. We just have a Chapter C tax structure. And you can get a few benefits in that you have a hard time getting anywhere else, particularly if it's a closely held business, because I'm not restricted in a C corporation by some of the ownership qualifications that I am in a Subchapter S or one of the other entities. If the owner wants the benefits, he may have to go to a C corporation to get them. But I don't think you want a C corporation. The benefits that you can get in a C corporation that you can't get elsewhere, in my opinion, is just not worth setting up the C taxation structure, because you take hits. The only way you can get money out of the C is to pay it out in salary, which means that everything is subject to Social Security, FICA, FUTA, and all that garbage. You're looking at 15.6% or whatever it is. And everything comes out as salary, or you pay it out as dividend, But when you pay a dividend out of a C structure, that isn't a tax deductible expense to the C structure. And yet you have to take it when you get the dividend, that's income to you. So the corporation had to pay tax on it. They didn't get a deduction when they paid it out to you, the dividend. And then you got the dividend and had to pay tax on it. That's the double taxation. So the answer would be very, 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 very seldom would I ever think that you would need a C corporation. You can get health plans, you can get HRAs, HSAs, you can get 401ks and all of that garbage, SEPs, you can get 412Is, you can get everything else in an S corporation. So I don't think you're going to want the C corporation structure. The question is, how safe are 401k plans versus gold or burying my money in a can in the backyard like great grandma used to do? The answer is I think that 401k, these retirement plans, they're under ERISA, the Employee Retirement Income Security Act, and they're pretty safe. I guess the government could start taxing them and taking them away from you, but that would be a far stretch. I mean, we've got to go way down the road to socialism before we get to the point where you can't have your retirement plan. The government still wants you to have a retirement plan. They'll give you benefits or good deals if you're willing to fund the retirement plan and everything else. I think the next step is that they will start to tax the 401k money when it comes out, which they already do, but they'll tax the benefits. They'll tax everything in it. I think that is a possibility, maybe even in the Biden administration. So I'd have a little bit of gold, a little bit of silver. I'd bury it in the backyard. No, don't bury it in the backyard. Nobody will ever find it. But it's not stupid to have some hard assets, and that would be gold and silver and stuff. And it's not stupid to have some cash at home. Do not get a bunch of $100 bills, because if the banking system goes down and we have to start paying cash for stuff, people aren't going to have money to make change. So get some smaller bills that you can go to the store, that you can barter with, that you can do things with. If we get to that point, which I really don't expect we're going to get to that point, but if we get to that point, we're going to be bartering all sorts of stuff, toilet paper, bullets, all kinds of stuff. But I don't think we're getting to that point at all.
You have a question?
Ben's coming in. Say hi, Ben.
Hi.
You got to come over here. We see your navel. No, come on over.
I know Julie Ploss.
Yes, Julie says that you've got her stuff and she wants to know where it is. You're delinquent.
She didn't say that. I know she didn't say that.
No, I just said that you and Lee were going to review my LLC paperwork, and then he called you.
Yeah. So what's the question?
She was just wondering where you were on the review.
Oh, we've been emailing you. Let's talk privately, so we're not talking about your taxes in front of everybody about that.
We had, if you guys need to, Ben will look at your taxes for you. You can upload them to a secure site on his website. Just scan them and upload them into that website, and then he can look at your tax return. It takes him 2-3 minutes to see basically if you're on the right track or not. We need to pick up your PPP money that you got this year. We need to pick up, you got a stimulus check. A lot of you got $1,200 back in December last year.
So,
and then you got another one.
Yeah, where that kind of comes into play is the PPP money actually is not taxable.
No.
But the stimulus, if you didn't get it and you are entitled to it, let's say they went off a not your most recent tax return, what happens is when we file your returns, we can recapture that amount that you didn't get.
So you can claim it and you'll get that basically through a tax benefit rather than from the treasury. So we need to make certain that you got 2 of the stimulus checks this year. What else do we need to? We need, if you're doing a little business or something, we need to make sure that you qualify for the 199 A stuff. 199A basically says that you add up all of your expenses, you get your profit in your company, and then we're just going to give you 20% of that off the top tax free. So your accountant needs to do that, but you need to have paid yourself enough salary last year in some cases to qualify. And some C entities, sole proprietorships, or even real estate people, they don't take a salary, so they don't get the 199A. Can we go back and pay a salary for last year at this point?
Yeah, you probably could. You'll get some penalties, so it may not be worth it. Well, we'd have to run those calculations.
So we just have to run the numbers, run the calculations.
And if you have rentals, we're going to actually record a webinar right now that will show you.
As soon as we get through here, we're going to record a YouTube video, and it's going to show you how you collect your stuff to give it to the accountant to do the rental deductions and stuff, the real estate.
Right. So we'll be sending you a direct link, Julie, and I'll upload stuff to your portal, and we'll be giving you a call probably by 5 today, our time. So we'll go through that with you.
Okay. Any benefits to Chapter C entity that you can see?
There's benefits, but I don't know of any benefits that would be worthwhile.
That's basically
for
what I said.
For our clients, unless you're publicly traded, there's nothing there for you.
You're going to avoid a C corporation, C LLC. It's just not worth it, guys.
By the way, the only reason the publicly traded companies are C Corps is because they have to be. It's required to be a C Corp.
Yeah, basically it's actually technically not required, but with an S corporation, you can only have 125 people. When I started practicing and S Corps kind of first came out, you could only have 25, but they keep upping it. So you can't really sell S corporation stock, and you can only have one class of stock, and you just can't do it. With the LLCs, you probably can't do it because you probably didn't choose transferability as one of the elements of your LLC. Do we have anything else? Oh, yes, we do have one. Let's see, it should be this one right here. Boy, my slides are slow coming up. We've got an individual who paid cash for property, and then he refinanced it. And the question is, can I deduct the interest payments off my taxes for that refinance piece? And then he refinanced it again and wants to know if he can deduct the new loan, the interest rates off of these taxes. And the answer is?
If you use the money to buy, build, or improve your property, it would be deductible. There's limits up to $750,000 of principal.
Now, is this on any piece of property?
It's a combination of your primary and secondary residence, right?
Yeah, but I'm buying a piece of, I'm buying a fourplex.
So that's the next part I was getting into. So that part is Schedule A, and if it's for a rental, there's no limitation, and it goes on your Schedule E.
And it doesn't matter whether it's the original financing or refinancing or whatever it is.
Correct. That's right.
So yeah, you can deduct the interest. The snakier question is I get a line of credit on my personal residence. Can I use that to buy a car and have the interest that I pay in my personal residence line of credit? Can I deduct that? And the answer is technically no. because you didn't use that money to improve that piece of property, the house and stuff. If you did, then you could deduct the interest, but where you bought a car with it, the answer is technically no. I don't see anything. So
Hey, Ivory's dog is making me tired.
who's Doug?
Ivory.
Oh, Larry's.
Is that Larry? It
Yeah,
says
that's
Ivory.
Larry. Yeah, the old dog's tired. But we usually deduct the interest on a home line of credit, and just know that if you didn't use it to improve the home, technically you can't.
That's right.
I didn't say you could. I said you can't. But I also said you usually do. So anyway.
Yeah, buy, build, or improve. But if you use the money for, if you refinance your property and you put that money in your business, technically your business can write that interest off too, right?
Yes.
So
the business could, but if I just go out, refinance my house and buy a car with it, I'm in trouble. All right, those were the tax questions.
right, you come get me.
Okay, I'll come get you.
See you guys. Talk to you later, Julie.
So we're back to how to change managers in an LLC. It isn't unusual to want to change managers in an LLC. One, you need to read your operating agreement. How does it say that you change managers? Is that just a vote of the majority of the members? Now, when you actually make the change, so I need a minute entry, which says that the members voted to remove Joe and put Gus in as the manager. We may have to amend the operating agreement because it may name the manager in the operating agreement, often does. So we are going to amend the operating agreement. Now, there should be a section in the operating agreement that says how we're going to do that. And also at the state level, you need to look at your papers that you got back from the state. And the question is the manager named in those papers? And they often are. So you may have to make an amendment at the state level. A number of states have you do an update automatically every year. They send you a form, you fill it out, you send it back. And if you're doing that, wait till you get the form, send it back with the other guy's, Gus's name on instead of Joe's name. So that's the easiest way to do the change of management in an LLC. See what your operating agreement says. See if you need to amend the operating agreement. And if you do, there should be provisions in the operating agreement that say how it's going to be amended. Now, if you've got one of the little itty bitty operating agreements from LegalZoom or wherever, it may not address how to change the manager or how to amend the operating agreement. If your operating agreement doesn't say, and it can say anything you want. I mean, your operating agreement can say you stand on one foot, you kiss the ground, and you have a meeting and you change the manager. Whatever you said is fine. But if you didn't say it, then your state has a default provision which tells you how to amend an operating agreement. So you have to drop back to the state. That's why I think you need an operating agreement between 30, 40 pages in order to address kind of the minimum issues that come up in the operating agreement or in the operation of your LLC, I should say. Now, some people out there, I've got one, I'm going to say competitor, who brags that he gives you a 150-page operating agreement. Well, that's a rule book that thick. And the fact of the matter is, you can't comply with all of that stuff. And when you get sued, I get you into court. And I read your operating agreement. And I say, did you do this? Did you do this? Did you do this? Did you do this? And as soon as I get you saying, no, 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 then I turn to the judge and I say, Your Honor, these guys didn't do what they were supposed to do to have an LLC. They didn't even follow their own rule book. I don't need to honor this LLC, pierce the corporate veil and let me come after them. And that's the way it works. I get to come after you. So, you know, it's damned if you do and damned if you don't. You got to have enough, but you don't want too much in your operating agreement. We have a disabled child, and the question is, do I use disability trusts? The money's got to be returned to the government if I use the disability trust. I don't really know what to tell you to do. If you don't like the disability trusts, then we've probably got a problem. I don't know what legal entity or form that you could leave money in and have it go to help the child and not have it qualify for consideration in Medicaid and the government disabilities and that sort of stuff. So the disability trust was designed so that I can have an individual, I can give them money, but I don't give it to them. I leave it to the trustee's discretion. And as long as the trustee, it's their sole discretion as to whether or not they ever give this disabled individual money or not, then it doesn't qualify and doesn't count against the individual for their Medicaid and their Social Security disability, food stamps, all of that sort of stuff. So that's what you do with a disability trust. And yes, I did go to McDonald's today for lunch. I usually eat at McDonald's, 4 or 5 times a week. You all know that I've had cancer badly, and I was the experimental animal, and they gave me experimental chemotherapies. What I found is if you eat at McDonald's a couple of times a week, it keeps your chemotherapy level up, and you can fight the cancer really well. It's a joke, guys. Anyway, so I'm not sure what to tell you. You're going to have to discuss this disability issue with some lawyers who are really expert in supplying the needs, the inheritances and stuff for disabled individuals. It's a whole science in and of itself. I have 2 companies. They're kind of related, and they do kind of related things. And right now they're sole proprietorships. And the individual that owns these 2 companies says, okay, I want to make an LLC. Can I make one LLC and have one of these companies under the LLC? And then can I make and can I just have this LLC own a DBA, a doing business as, and have the second company, and it would be protected under the first company? And the answer is yes, you can do that, no problem. Excuse me, chokes me all up. In fact, when they're that related, the risks are the same, everything's the same. You can certainly have a DBA under the one LLC and not have to do 2 LLCs. If you're in a state like Utah, where it's $150 to set up the LLC, and then what is it? I think it's $15 a year to keep them going. Have 2 LLCs. If you're in California, where it's $850 a year to keep one going, then maybe I would have the one LLC with the DBA underneath it. Wouldn't be a bad idea, and you can certainly do that. We had the question, can I refinance the properties and still deduct the interest? I think we've already addressed that one, and we did not have a lot of questions this time. So we're down to the follow-up questions. Nobody's typed anything in the chat. Why don't you just unmute yourself and ask the questions?
I have a quick question. When you were talking about adding a manager, you need to make sure that you update your banks too, right? Because
yes, because we're going to have a different signature on the signature card at the bank. So yes, you're going to have to take the resolution that says that we named Joe as manager or Gus is manager, and Joe may have to go down, probably will have to go down to the bank and say, yes, I'm turning the reins over to Gus. And so that would,
How many
allow-
managers do you have?
what's that, Julie? Say it again.
How many managers should one have?
Well, if it's your little company, probably one. You're the dude.
Yeah,
You
if
know,
you're
if
like
I've got a
a-
company that has $20-30 million a year in income, then I may want to get a second manager to help manage. I can bring in another manager, but only if I have chosen manager managed on my LLC. Remember, you asked the lawyer, should I have member managed or manager managed? And the lawyer said, it doesn't matter, just pick one. Well, it does matter. It matters for a number of reasons. And one of them is if I pick member managed, then only a member, only an owner can serve as a manager. I can't go out and get a hired gun and bring him in and operate my company. But I mean, how many of you want a hired gun operating your company? Come on, give me a break. You're not going to do that. It's going to be you. It's you. It's your company. Now, you do have to think that you're wearing the manager hat. And when I'm acting as manager, that's not the same as me. It's a different dude. I'm a different person. And you need to act in that capacity. And the way we attack the corporate shield, the way we attack your LLC is to start showing that when you were wearing the manager hat, you were actually doing personal stuff. We commingled the money. We did personal stuff when we were wearing the manager hat. So you got to think, where am I acting? Am I acting as me, the individual, or am I acting as me, the manager? So you wear different hats, and I could also have a trust, and I could take off the manager hat and put on the trust hat. So where are you acting? How are you doing it? I have a question. When I transfer my LLC ownership certificates from my name to my Living Revocable Trust name, you want to do that so you can avoid probate. So the Living Revocable Trust is going to own the company. Now, does that mean you have to have manager managed? And the answer is no. Your Living Revocable Trust is a disregarded entity. We still think it's you. So I'm going to move my ownership from my name to my Living Revocable Trust's name. Does my signatures on minutes, annual meetings stuff, documents change? And the answer is, if I'm wearing the manager hat, it doesn't change. But if I'm wearing the member hat, yes, it does change, because you're not the member anymore. Technically, your trust is the member. So you will sign John Doe manager in one place, and you will sign John Doe trustee, TTEE, or however you abbreviate it, in the other place, so that we are identifying where you are. But yes, you will change the way you sign as the owner, because you're not the owner anymore. The trust is the owner, but you're the trustee. So you have to designate that you're signing as owner trustee. Do I have to sign as trustee, or does nothing change? I think we answered that. Yes, you are still a manager. How do we determine if we are eligible for the ERTC in 2021? What's ERTC? I guess that's stimulus crap. Who asked that? Mary Ann? We don't see Mary Ann. I don't know what ERT, employer retention tax credit. Oh, okay. You're retaining your employees under PPP, and as long as you pay them the same and stuff, you get a tax credit. Now, if you've gotten the PPP money, you don't get the tax credit. So you've got to watch that. But I don't know, to be very honest with you. They've done another round of the PPP, but to be honest, I don't know if they've extended the employer retention tax credit. I just don't know. Anyone else? Come on, Robert, you're just sleeping there.
I have
Yes,
a
Lenny.
question.
Yes,
Uh,
Jeff.
Can you explain Article
not
2 of your AB Revocable Trust?
Say it
want to
again.
talk
I didn't
about
hear
the
it all.
trust. Excuse me?
Say it again. I didn't hear it all.
Can you explain Article 2 of your AB Revocable Trust?
Okay, I don't have Article 2 in front of me. As I remember, Article 2 is what happens during the life of the husband and wife. Is that correct?
Yes, and it talks about paying out income.
Well, that's a very good point. The trust and most of the trusts have terminology that says that you're going to pay out all of the income in convenient installments, at least quarterly or at least annually. When it says pay out in the trust, that doesn't mean that we take money out of the trust account, the bank account that the trust owns, and we take it and put it in another bank account. That's not what it means. What it means is I recognize that income as my income on my tax return. When the trust pays out, it gets a deduction for the money that it pays out. Your living revocable trust is not a trust that can accumulate income. Trust that cannot accumulate income, that has to be paid out to the beneficiaries, is what we call a simple trust. A trust that can accumulate income is what we call a complex trust. You do not want the trust to accumulate income, because then it would have to file a 1041 return. You file a 1040, your trust files a 1041. The problem is, and some of you have a living trust and you've gotten an EIN number, tax ID number, then you do have to file a 1041. But you want that 1041 to show zero income, because at like $13,000 this year, 13,275, or it's a weird number. But at $13,000, the trust hits the 37% tax bracket. You don't hit that until after $400,000 in income, but your trust is paying 37% out. So you always pay out all of the income so that your trust doesn't have any income, even if you file a 1040 form, because you don't want the trust to pay on the money that it gets. So you always pay it out. It says in Article 2 that you can use the principal. And it says we use the principal for your benefit. We had a case a number of years ago down in the middle of our state. Mom had taken a farm out of the trust and deeded it directly to a son. And we won the case because the two sons were killing each other. They were suing each other because the other son wanted his share of the farm. Mom had deeded it out directly to the son, but the trust said that the assets could be used for mom's benefit. So if mom had taken the principal, the asset, out of the trust and deeded it to herself, then she could have deeded it to the son. That's not what she did. It went directly from the trust to the son, which was a violation of the trust rules. Can you see it? So you kind of have to pay attention as to how it reads, but you get all of the income. You can use the principal, the assets of the trust any way you want. Article 2 says that you can amend the trust. You can restate the trust. You can do whatever you want that way. And there's another provision in Article 2 which says that you can make stupid investments. Technically, if you understood what a trustee was, none of us would ever serve as trustee. It ain't going to happen, because it's a very high responsibility. If the bank is trustee, you're never going to make any money on the accounts in the trust, but you're never going to lose the money either, because technically the trustee is liable for any loss of assets in the trust, personally liable. So the bank is never going to lose those assets. And we have a provision in there that says, yeah, we know that you're a stupid investor and you might lose assets. It's okay. You're the guy. So those are the provisions, the paragraphs in Article 2 of the trust, I'm pretty sure. Other questions? Dan, did that, is it Dennis? Who's Dan?
Yes, Dennis. Yeah, that
Dan
answers the question.
That answered. Okay, good, good.
Yes, thank you.
Yes, Lee. Jeff Kime here from Lima, Ohio. I had a question.
We'll forgive you. I spoke in Lima once.
Oh, did you?
The little university's there, right?
Yep. Racing
Yep.
school university.
Yep, I spoke there. Go ahead.
So I have a single member LLC. I'm going to add my sister to it. But right now it's single member LLC taxed under Subchapter S.
Fine.
I'm not really paying myself right now, but do I have to pay myself a salary? And
Well, you have to pay, the law says that under Subchapter S, you have to pay yourself a reasonable salary, and then you can distribute the rest of it out. The reasonable salary, the W-2 salary, is subject to Social Security, FICA, FUTA, and all that crap. The distribution part, the dividend, is not subject to the Social Security, FICA, and FUTA and stuff. So you can pay that out and save that 15.6% right now. What did having your sister, the other person come into it matter?
so I have your LLC wizard. It's kind of a separate question. I have your LLC wizard, and when I filled out my operator agreement, I pretty much chose the second selection for a member managed operating agreement, which is
Okay.
more beneficial.
So is she going to be a manager too?
No, she's not going to be anything to do with a company, just for asset protection, basically, by having a second.
Okay, well,
member.
I don't think, pretty sure, Ohio does not require a second member. And
Okay.
that isn't for the corporate shield, that's only for the charging order protection. I think the trend is to make it so that the charging order protection does require at least two members, two owners, because the concept of charging order protection isn't to protect you, it's to protect the other guy. And if there's no other guy, then why do we need charging order protection? That's a real short answer to that. So you could check and see if Ohio requires multiple member LLCs to get the charging order protection, but I don't think they do right now.
No, I don't think they do either.
It may change, and you'll certainly be aware of it when it does change. But right now, I don't think they do. Florida does, Massachusetts does, Utah, Idaho and Massachusetts actually have laws which say I need multiple members. The Ninth Circuit, the wackos up and down the West Coast. Who's up and down the West Coast? Larry? No, it was, he took off. But they require multiple members for protection in bankruptcy, only bankruptcy. So it's kind of iffy today, but you know, if you want to have another member, it won't hurt anything. If there's some reason to give them an interest in the LLC, that's great.
And
Other questions?
Would the operator agreement change a lot? Would I have to select something else different?
Just read the operating agreement and see if it talks about single members and stuff, and where it does, you're going to have to change it to multiple members.
Okay, thank you. Thanks.
All right. Should we give it up,
Hey, Lee, I got a question.
David?
Yeah, I got kicked off. The connection was bad there for a while, so I'll have to catch the replay. I've got a, this is a LLC or an S corporation, LLC filing as an S corporation. I've got a coaching student that paid me a coaching fee, and then he formed his LLC as an S corporation to start, rehabbing houses. How is there any way for him to write off or use that expense for the coaching fee, or did you have to depreciate that over time, or how can he try to recoup that?
No,
Since he
he
paid the
should be
fee
able to
first?
just write off the coaching fee. Just write it off. One, he's got less than a 1% chance of being audited. And two, if he does get audited, it's perfectly appropriate to pay for a coach or to pay for a aid or education and stuff in the LLC.
Okay, even though he paid the fee a couple weeks before I, talked to him about his entities and stuff, and he formed it after he paid the fee before he formed the entity.
Well, that's fine. Lawyers get people to pay the fee all the time before they talk to them.
Well, if it's good for them, it should be good for us.
I don't, by the way. I've never done that. I don't have, if you do that, you have to have a special trust account to put the money in. And I have never set up a special trust account because I've never charged anybody in advance. And so I just haven't worried about it. And I've only been stiffed twice in 40 years, which is amazing because most law firms will carry a 20, 30, sometimes even a 40% bad billing.
Right. Yeah. And I think I'd sent this question in, and I may have missed it because I got dropped off. But with the C corporations that are out there, and then some of this CARES Act stuff that's coming out with it, I thought that there was a benefit that a C corporation could pay back an employee's student loans up to 5,000 or up to a certain amount. Do you know anything on C corps where they have that advantage?
I don't know. We're going to have to look at the CARES Act specifically, but $5,000 in my mind is no justification for filing under Chapter C of the IRS code at any time.
Oh yeah,
Just-
no, I've already got the C corporation already. So
My
I have the
question
C
is, why do you
corporation.
have a C corporation and how dumb are you?
Well, no, okay,
sorry,
so
David.
I can explain it. Okay, it's
Well, give me a call and we'll explain it personally. How does that sound?
okay. Yeah, I was going to say I don't want to take up the whole time here with everybody on why, but yeah, we can do it.
Yeah, I'm
offline.
gonna, I think, have Ben come in and we're gonna do a YouTube video on preparing real estate stuff for your taxes. And I've got a 3:20 appointment that I'm gonna have to run to in a few minutes. So
Okay.
can we sign off for this week?
Yep. Yep.
All right, everybody. Thank you.
Thank you.
Have a great month and we'll see you back. How does that sound?
Sounds good. Thanks, Lee.